to the program. I'm Marty Shenkman. I'm joined by my friend and colleague, Alan Gassman. Say hello to everybody, Alan.
Hello, everybody.
And this is the fourth installment of our monthly webinar series. And each month we've been trying to get together and do a really informal discussion between us and you of things going on, things that we see in practice, recent developments, whatever we see going on. And we appreciate any comments, input, thoughts you have, things you want us to address, suggestions, all welcome. The best thing is just email Alan or I. And because we're doing this informal and updating it until literally 2 minutes ago before we started what we're going to cover, we're not preparing PowerPoints. We thought, a little conversational presentation would be a break from the more formal webinars. And need I remind any of you that Alan typically has like 200 slides on his average webinar. So you almost need to have a double cappuccino to watch it. So Alan, let me start with something that seems really trite and silly. We keep seeing it happen over and over, and please make any comment you want. And this is not meant to offend anybody, but I just don't understand why it keeps happening. We'll set up an estate plan for somebody, and let's take something really common and basic and simple. There's a revocable trust, and we'd want the non-pension assets retitled to the revocable trust so that they will pass in accordance with the estate plan. And that's communicated, and there's a cover letter explaining what has to be done. And as is typical, the client says, no, I can talk to my financial advisor. And there's a cover letter that says, do not retitle retirement assets. Please retitle non-retirement assets into the revocable trust, and here's the name of it and the date of it and everything else you could need. Not complicated. And then when somebody passes away, we find that the assets were all made joint pay on death or and nothing goes according to plan. And I'm a little baffled because I'm not even talking about anything very complicated or unusual, especially funding a revocable trust. And I'm baffled because there's such an increased awareness amongst financial planners about estate planning, and so many of them are trying to be involved, and I welcome their involvement, but let's start with something really basic and important. Let's get the titling on assets done correctly. And we had a situation now where if the surviving wife remarries, all the assets are exposed to a new spouse potentially, as opposed to being in, whether it was a Q-tip or credit shelter, doesn't even matter, but nothing's going to work as planned. And we keep seeing this happen. And this sort of in the same theme, and then I'm done, we see where financial advisors want to be really helpful and somebody passes away, so they immediately retitle everything to the name of like the surviving spouse, ignoring all the trusts that may be under a will. Have you seen this? Do you have any insight, thought, suggestion to financial advisors that may be listening? Anything?
Well, I think the best advice is be in touch with the lawyer who drafted it and make sure that there are written instructions or some sort of a dialogue of emails setting forth exactly what you're doing and exactly what you should be doing. And when assets are titled to a trust, you probably don't need a pay on death designation. And we do see these errors time and time again.
Significant. We've just had a whole slew of them, and talk about undermining a whole plan. I think one of the things that financial advisors should be mindful of, if I say to a client, can I call your financial advisor and go over the letter with them that I just gave you, or that maybe we even were authorized to send them, the answer invariably is, I'll take care of it. And and I know, I'm going to say it, clients, I don't need that lawyer billing for another hour to call the financial advisor. It may be 10 minutes, it may be 20 minutes, but it's an important 10 or 20 minutes. If you're a financial advisor and you're not sure how things should be retitled, please don't use these sort of simplistic avoid probate at all costs and don't think of anything else approaches. You need to tell the client, hey, client, I need to talk to your lawyer to make sure I know what the plan is so that I can properly title your accounts. And I think that's protective of the wealth advisor. I think if one of these clients got upset and the wealth advisor retitled everything contrary to what the plan was, they may have some culpability there. But understand that when I say to the client, or Alan says to the client, he may be more persuasive than me, but I don't know, let me talk to your wealth advisor. A lot of times the answer is no. You, the wealth advisor, have to say, client, yeah, I do need to talk to them, because that's the only way we get this done. So that was a quick one. I know everyone knows everything we just said, but we just keep seeing it happening over and over and over again. So, Alan, have you, and I suspect if you haven't, you're in the vast majority of practitioners, have you paid any attention or looked at this proposal by Van Hollen, strengthen Social Security by taxing dynastic wealth?
No, I have not looked at that.
Oh, okay.
Sounds pretty scary, though.
Well, I think the reason nobody's looking at it, but I think that's a dangerous mistake, and let's just ponder this. The bill proposes, just like so many other Democrat proposals, but I think it's very clever and strategically done, more so than most of the other ones. For more than a decade, Sanders, Warren, Von Hollen, they've all been proposing, lower the exemption, eliminate grantor trusts, and so on and so forth. And they've never gotten it through. And the only reason they didn't get it through was Cinnamon and Manchin, or they probably would have had it through years ago, and we'd be in a very different tax environment. So Von Hollen's bill proposes lowering the estate exemption to $3.5 million, not inflation adjusted. So imagine what that's going to be in 10 years. 3.5 from the current 15 is a whopper of a change, and it's the tax that keeps on taxing. I like that phrase, because without an inflation adjustment, it's going to get just worse and worse. They didn't mention GST. I think it was just an oversight. They'd fix that. The gift exemption, 1 million. 1 million. So think of what that does to inter vivos planning. It's a whole new ball game. What I thought was very clever and strategic about it, it's not just we're going to tax those bad rich people because we just want to and they're bad. This was very, I think, strategically thought about. Social Security has got financial issues. Everybody knows that. How are you going to fund it? Well, he proposes taking some of this additional estate tax collection and putting it to fund and fill the gap in Social Security. The government cannot, at least in my view of the world, cannot possibly, due to the people receiving Social Security, what's done to TSA. I mean, if people don't get their Social Security check, I don't even want to think about the potential outcome. I mean, you'll have people starving. And I don't know how those folks, and I feel terrible for them with TSA, are getting by either. Grossly unfair. But by tying estate tax increase to funding and solving the Social Security problem, it may have more strategic ability to get enacted at some point than if not. So I think it's something worth thinking about. And I think too many clients have and practitioners, it ain't getting signed by Trump. That's, I think, a pretty foregone conclusion. He will never sign it. Alan, you don't see anything changing on the screen, do you?
Nope.
Okay. So I think a lot of people just really haven't focused on it because the likelihood of getting enacted with Trump in office is probably zero. On the other hand, I think his strategically, and I don't think it was happenstance, tying estate tax increases, substantial increases, to funding Social Security may carry a lot more clout, because we cannot risk a situation in this country of not being able to fund Social Security. So I think it's a very intriguing prospect proposal that people need to give more thought to. And let me pause for a second and say, this is not in isolation, and I think that the bigger picture also needs to be looked at. California proposed a billionaire's tax. I don't think it's going to go through. Washington enacted a very high tax rate on people earning over $1 million. If I remember the number correctly, the Washington state estate tax has got like a 30 or 35% marginal rate. Mayor Mondami in New York, he doesn't have any ability to really propose or enact estate tax increases, but he's suggested and floated the idea of a mere $750,000 exemption. And listen, whether people like him or not, he's a very shrewd, smart guy. And I think what might be going on there is he may have floated the 750 as, you know, this is the first salvo over the bow. Maybe we'll settle for 2.5 or 3.5 million to match Von Holland's bill. But Kathy Hochul, the governor of New York, may very well need Mondami's endorsement and help to get reelected. And if that's the case, you know, she may give great thought to his desire for a much lower estate tax exemption in New York to pay for social programs like free busing and free childcare. So, and I just read something interesting where his view is, if people of high income and high wealth pay more in tax, then they should also qualify for the free childcare because they're paying their fair share. So I think to ignore this strengthened Social Security by taxing dynastic wealth bill is potentially a mistake. And now I'm going to say something which sounds incredibly self-serving, because this is what we do for a living. But I really think if I hadn't done my own planning, I would probably try to get on the stick and get it done, because you don't know when this stuff will change. You don't know to what degree it will change. And just like, and you're kind of young, but were you practicing in 2020 and 2021?
Of course.
So, you know, we were afraid of, and I remember we all spent a lot of time on webinars talking about the legality of a retroactive tax bill. You know, if the Democrats win in the next presidential election and get control in Washington, they may put a retroactive date on these kind of changes because it was proposed in 2026. I think that people of means should really evaluate not just this one proposal in isolation and dismiss it because Trump won't sign it. He won't. But there's a real, I don't know if trend is a fair word to use, but there's certainly a movement continuing with a lot of states and those in Congress to push through much harsher changes. And if you do the planning now as opposed to waiting, gee, you're only getting more asset growth out of your estate. You only enhance the likelihood of grandfathering it, and you get the asset protection to boot. So why keep putting it off? And I think there's things that we may want to, you know, communicate to clients, and I'm going to update some of the forms we have, just saying, hey, this is out there, because I don't want someone coming back and saying, hey, you didn't tell me. I'm telling you. So it's certainly not a standard of practice. It's only a bill, and the likelihood of getting passed in the near term is zero, probably zero. But I think it's something people should give thought to. Any comments, thoughts?
No, I think you're right. The estate tax exemption could well go down by half or even more after the next presidential election, and people just forget about that, and they say, well, I'm at 30 million for this married couple, I'm okay. Well, not if you move back to New York and live with your children in your old age.
No, New York's 7 million, but they're talking about making it 10% of that.
Wow.
And you know what?
So this could happen. There's no doubt.
Listen, if the $3.5 million in Manchin's bill doesn't fly, so they'll make it $5 million. But there's an awful lot of people that, you know, at the $15 million exemption, this is off radar. But on the a $5 million exemption, it's a major issue. And what are you gonna do? Wait till you have health problems after it's enacted? It's not worth it. Let's talk about asset protection. I think on one of the last programs we talked about the Delaware case, and I may get the name wrong, but it's something like CES 2007 Trust.
Yep.
My understanding, a take home of that case is if you set up a self-settled trust well in advance of having any problems and you do a lot of things right, even though a lot of things weren't pristine in that case, that trust will be respected. I know the individual defendant got tagged because he had put some real estate gratuitously into the trust after a Michigan court said you better not make a transfer. But the trust, the Delaware Asset Protection Trust, remained respected. We've had two more, which this is a big run for asset protection cases because we haven't had that many in 20 years, and we got three fairly close in time. We have two more cases. One was Huckabee, which was a California resident who set up a Nevada DAPT, and Huckabee came out just recently, March 3rd, 26, Eastern District of California. Huckabee had real estate in California that he purported to transfer to a Nevada self-settled trust. Alan, do you know who this trustee was of his self-settled trust?
He
Himself.
Yeah. And we've been reading the appellate briefs, and he was a lawyer practicing at the time.
Whoa.
He did. So he and somebody else, I don't know if it was his partner or his significant other, he and this lady had this jointly owned property, and they put it in this irrevocable trust with themselves as trustees for themselves, and said Nevada law will apply, even though it was clearly a California trust. And they did it well before they were having the problems that the IRS went after them for. So it was perfectly, it was funded completely before he owed all this money to the IRS. But then, even with this flimsy trust, which really was hardly worth the paper it was written on, it took the IRS a long time to get into it, just because of the whole judicial process. So this federal court judge just says, sorry, Charlie, but this is a California trust because it's California trustees and California real estate. So California law applies. You're a beneficiary. So here's these assets to the IRS. Thank you very much.
Alan, how simple would it have been to have done it in a manner that may have been respected? What would it have taken? I think only two main things. I didn't see the trust document, so I don't know what was in the trust document. He could have named an institutional trustee in Nevada. There's no shortage, lots of good institutional trustees in Nevada, and it doesn't even cost a lot. And what would you have done with the California real estate? I know the answer, but tell everybody, and they probably know the answer too.
Put it in an LLC.
Wow.
And let the Nevada Trust Company own the LLC.
Isn't it a shame for someone to go through planning and for such simple, common, certainly known to anyone who does this work steps, blow the plan?
Yeah. Yep.
And we all get kickback from clients. I don't want to spend the money on this. I don't want to spend the money on that. Getting an institutional trustee in a DAPT jurisdiction is an insurance policy to make your plan work.
Right. Now, we still don't know what the federal court would have said if it had a Nevada trustee, if it had an LLC, whether the full faith and credit clause would allow a California court to come to the conclusion that California law should apply, whether a Nevada court would have had to respect that under the full faith and credit clause of the U.S. Constitution. But this is not a case that we're going to learn that from.
No. Now, I think the Delaware CES 2007 Trust, the Huckabee, the lessons from both of those: do things right, get a correct, an appropriate trustee, don't have any real estate or tangible property outside of that jurisdiction owned by the trust, and do whatever you can to enhance your ties to the jurisdiction you're in and observe the formalities. I mean, one of the things that the Delaware court said when they upheld the Delaware Asset Protection Trust in the CES 2007 case was the requirements of the statute were met. The conduct and administration of the trust was not pristine, but they checked the boxes for what had to be done to comply with the Delaware DAPT statute. We just had another case come out, which I'm still analyzing. It may be worrisome, but it's like so many of the very few DAPT cases, so many of them are just really bad facts. I would put Huckabee in a really bad fact case. I don't think any practitioner would set up a trust with somebody in a non-DAPT jurisdiction being the trustee and owning real estate in a non-DAPT jurisdiction and think that they've accomplished anything. But the Netter, Netter, is a matrimonial case that just came out at the end of last year, very recently in Connecticut. And Netter was very similar to a recent New York case. I think it was RH versus another set of initials. And the consequences were the same, that the plan was pierced. In Netter, the individual had 4 trusts. One of the trusts was a trust that his father had set up and was not marital assets. It was a spendthrift trust, and that trust was respected. The court did look at the powers that the husband had over the third-party trust set up by his father, which kind of suggests that, you know, you want to be careful having, and probably want to avoid having, the client as the trustee of the trust, even with a HEMS standard, because if you can control a HEMS distribution, the court may have ruled differently. But in Netter, on the third-party trust set up by his father, he had no authority to make distributions. Only an independent trustee could. My preference when we're doing any of these trusts is ideally, other than an investment trustee, which is not a tax or liability asset protection sensitive function, I would only have independent trustees. That's, I think, a better approach. If a client really wants to be a trustee, then don't let them make distributions to themselves, because under the Netter case, that could be problematic. But that was respected. And I spoke briefly with Jonathan Blattmacher about it. And he said, I'm the most the biggest advocate for everything to be in trust anywhere ever. But he's right, because if it's in a trust that somebody else creates, don't leave things out, right? Leave them in trust, and you got a much better shot. So that was that piece of it, and that makes sense and should have been what was found. There were 3 other trusts, all of which were self-settled trusts set up in South Dakota by the husband, and they shouldn't have been. The transfers shouldn't have been respected, and you may have some nuance to comment on this, because the husband was, according to the case, the way I read it, a bad guy. No offense to him, I don't know him or her, but the husband, according to the way I read the case, made transfers of a substantial portion, maybe more than a majority of the marital assets, to self-settled trusts during the marriage, knowing the marriage was on the ropes. Not the phraseology the court used, but that was the point. So the marriage is going south, and he moves all these marital assets into self-settled trust, of which he is the only beneficiary, not even the kids, just him. So yes, unlike Huckabee in California, he named a institutional trustee in South Dakota, followed all the rules to have a proper self-settled trust in South Dakota, but it was really a fraud on the marriage, because his wife, she didn't even know that he made the transfers. How can you transfer marital property in a marriage, especially knowing it's going south, to a trust only for your benefit and imagine it's going to work? That's bad, right? Go into timeout and don't come back. So, Alan, what the court sounded like it did is say, hey, we are not going to respect these trusts because we're going to apply Connecticut law, not South Dakota law. And we're going to apply Connecticut law. And this is the part that was worrisome to me. And I just started reading it and analyzing it, so I may not have it right. But we're going to apply Connecticut law because Connecticut has a very strong public policy addressing this matter. It would have, and you can comment much better than I on this, but it would seem to me that what the husband did was a fraud on the marriage. It was really deceptive. Maybe the transfer should have been or could have been disregarded without questioning the trusts, which were validly formed. If the transfer is disregarded, it's a fraudulent conveyance, you pull the assets back. But what worries me a little bit is if this is a precedent where at the time, Connecticut was not a DAPT jurisdiction. It's now a DAPT jurisdiction. And that's similar to the CES 2007 Delaware case because the guy was in Michigan and set up a Delaware DAPT at the time when Michigan didn't have the statute. But when you did this transfer, we're not going to respect it because we have a public policy against it. Thoughts, comments?
Well, you have to be careful when you do this trust planning from a marital standpoint. So the Connecticut, I haven't read the case, Marty. The Connecticut court just set aside the trusts and gave them back? Like it was a fraud on the marriage?
They disregarded the trusts. It seems that what they did is they applied Connecticut law to say that we have a strong public policy. And I get the public policy. I mean, it was like a complete fraud on his wife and on the marriage. I mean, he transferred marital property during the course of the marriage, knowing the marriage was going south, to a trust that only he could benefit from.
So the court of equity said, that's a no-no. I'm setting this back aside. Maybe it was on the doctrine of constructive trust. I don't know.
I didn't see that.
If the court had the authority over an irrevocable trust, whether that was a party in front of them, I don't know.
So this is something we have to think about. I mean, clearly, doing transfers to self-settled trust when you know you're in trouble is not going to work. I mean, that seems to be a foregone conclusion. I'm trying to think of a polite term of being egregiously unfair to your wife. I first thought came to use a term that may be less appropriate to say, but committing what I would call a fraud on the marriage is just, it's wrong. And how can you be allowed to get away with it? The issue that worries me about the case, and that's why I said it's going to take, I haven't seen much on it. There have been a couple of blogs on some law firm websites. There's no major articles, no lectures, nothing on it, which is a shortcoming we'll have to all rectify. But I'm sure in time it will be. But, what weight do we give what the court's analysis is to unwind this? Did they say that the trust is invalid? Did they exert Connecticut law and now we have a problem anytime someone sets up a trust in a DAPT jurisdiction when they're in a non-DAPT jurisdiction? And I would go a step further. If that is in fact what what we learn from this case, if you're in a DAPT jurisdiction that has a more, I don't know if lenient's the right word, but a look back period for, alimony and child support, and you go to a state that has a shorter period, will your DAPT state apply its law and not the jurisdictional law of the state that you set the trust up in because it's different and they have a public policy purpose? I mean, the problem with this, Alan, is we all, just from the brief facts I've given you, we get the public policy. This was bad and we got to get some equity done here. But what lessons and does it have for the future of DAPT planning? That's the bigger question. But I also think, and again, this is just off the, I haven't had a chance to really write it out or evaluate it. I think it was the Huber case in Washington State, if I remember correctly, where the guy was also a bad actor, and he had, I think, several mortgages in default on real estate properties, and was in a lawsuit with his real estate partner, and purported at that time to transfer assets to an Alaska self-settled trust. And Washington said, we're going to apply Washington law, and none of this works. It may be similar, and I think Huber was the case. I may have the wrong name, but I think it was the Huber case, because it wasn't Mortensen, and I don't think it was Klabaka. I think it was Huber. But I think Huber may have some analogous lessons to what Netter did in Connecticut just recently. And I think we need to evaluate that. But I think it's important for everyone to have all this stuff on their radar screens. Alan, any recommendations, thoughts? I know it's preliminary, and I'm sure you will study it and parse through it at some point. But any thoughts just now for people doing this type of planning?
Well, for one thing, if it's the IRS involved, it could be tax evasion and fraudulent of a felony to help someone move money away from the reach of the IRS. I was surprised that that wasn't mentioned in the Huckabee case until I realized that he moved it well before he had the IRS problem. You could put some, if you have a particular issue, you can put something in the trust that says that the trustee can pay the IRS or can pay a particular known creditor. You don't necessarily have to wait until the situation at hand is resolved. If you set up an asset protection trust that says, I recognize that I'm going to have a jury trial against Marty Shenkman in 5 weeks, and if he wins, the trustee will pay whatever I owe him from this trust, but I'm saving the rest, my assets, from the rest of the creditors, and that's called a Jones clause. But yeah, we always have to realize and remember every client, married couple we have could become a divorcing couple, and every trust we fund could have an impact on how the family court judge is going to resolve things. And when a client calls me, or a potential client calls me and says, I need to move some assets away from the reaches of my spouse, I say, the first thing is, I'm not the right lawyer for you. You need a family lawyer, not a trust lawyer.
To start with.
Rule number 2 is, don't do anything that's going to make the judge angry in your divorce. People do that all the time. I'm even surprised when divorce lawyers send clients to me and say, oh, this person may get divorced. Can you save his assets from his spouse? No, I cannot. That's not my job. That's not what we do here.
Well, especially when it's as egregious as the facts in Netter. I mean, it was just like the recent New York case. Courts don't appreciate one spouse, and in both of those cases, it was the husband. But they don't appreciate one spouse really just blindsiding and ripping off the other spouse. You have a fiduciary obligation to your spouse. You know, it's why a prenup before you're married has more clout than a postnup, because you don't have an obligation to somebody you know that you haven't married, and the further before, the less likely someone is to impute that. So I think these were clearly, they're bad fact cases, but there still may be some fallout that we have to contend with or think about. But if I'm right, if the Huber case, and there was you know, those existing claims, that didn't end the use of self-settled trusts. So maybe Netter won't either, and we need to all think about that. But I think all this has to be on the radar screen. Now, I feel like, you know, I have to bring forth Steve Ocean's name, because I hear him saying this. Well, why would anyone do a DAPT? Do a hybrid DAPT. You're not a beneficiary yet. That may be helpful if there's issues with DAPT, so why not? Maybe, but it still doesn't solve the bad actor case, and I don't think he would imply that either. But Alan, I know we're recording this, but I'm going to say I'm a little surprised and disappointed in you. And you had an opportunity. It was an easy layup to plug Estate View, and you didn't do it. So because you're off your game, I'll do it. This is why, folks, you take Estate View and you do a detailed background check, because some of these issues that are out there may be identifiable by you And what does it take? 5 minutes, less than 5 minutes, and a click?
Yep.
And then you review, it could be a 10, 20-page background check to see if anything, untoward comes up, and then you ask some more questions. Alan, what happened to you?
Just be careful out there.
All right, that was a layup. I don't know why you didn't, an opportunity to plug your software and you didn't do it. Okay. But Netter is a new case. We all have to evaluate it. There's, I'm sure, going to be a stream of articles out on it. Huckabee, bad facts, CES, helpful facts. But these all give us, what is it, buoys, markers to sort of navigate around. And we need to be cautious. But having some law does help. Let's change gears completely. Alan, you wanted to mention something about using convertible notes to add basis.
Right. So this is a Stacy Eastland technique that can be very important. So if I have $1 million building, it's highly appreciated. I put it in an LLC. I own the LLC, and I take back a $900,000 note. The note is interest only at the applicable federal rate, let's say for 15 years, my life expectancy, perhaps. And it also says that at the moment of my death, a percentage of the LLC will become owned by me, by my estate. So if the note is 900,000 and the LLC is worth 1.8 million when I die, then the note converts into 50% ownership of the LLC. The LLC is a partnership for tax purposes, and my inside basis of the assets of the LLC, half the assets of the LLC are 900,000. So I basically get my step up, even though when I transfer that LLC to the Dynasty Trust, I call that, based on my math here, a $100,000 gift. The future growth of that shopping center is out of my estate. But when I die, I've got 900,000 inclusion, the face amount of the note, which, as I said, becomes a 50% ownership interest in the LLC, which gets a step up in half the assets. So when you're sitting here with all these grantor trusts owing these grantors all these notes, and the grantor is going to say, hey, under revenue ruling 2023-2, there's no step up through the grantor trust. Well, if you rearrange the note so that the note is from the LLC and convertible, that may solve the step up. Now, does that cause inclusion in your estate under 2036A? And I don't think it does, but even if it did, would it just be the value of the note, the value of half of the entity? So I think it's worth looking at, especially when you compare it to the other method of getting a step up in a freeze situation, which is preferred and common partnership interest. If I had put that building into an LLC and I retained a preferred interest and gave the Dynasty Trust the common interest, that could have the same result, including the step up on the preferred interest when I die, but that's a lot more complicated. And the hurdle rate for a promissory note is the applicable federal rate. The hurdle rate for a partnership freeze is going to be usually a lot higher than the hurdle rate.
And a lot less certain.
And a lot less certain. That's right. And very expensive to put together.
It's complicated and costly. And not a lot of people really do these. I spoke to a whole bunch of colleagues, both from an appraisal side to practitioners, about preferred freezes with an interesting twist and an idea I had, I don't know, maybe 6 months ago. And I was actually surprised that a lot of well-known people that I've heard lecture on it have not done them. And I was surprised at the dramatic difference in knowledge base of some of the different well-known appraisal firms on this. Some were incredibly like all over it, and others not so. when you do a preferred partnership freeze, just since you brought it up, do you use defined value mechanisms to protect that preferred return in case it's not pegged at the right level?
I have not. I've not seen that, but it's
That
a
was the
great
issue that I was talking to people about, and I found that the vast majority of people that I talked to, nobody really talked about it or did it. Um, um, Todd was the one guy who was all over it and said absolutely, but it's a very different kind of. It's not like your typical simple laundry clause. It's a little more complicated because you're putting a valuation. You're doing an adjustment mechanism on a preferred payment, not on the value of like the LLC interest. But that's something to keep in mind. And that's another reason all those twists and complexities, a note sale, we all know how to do a Wandry or Christensen or Petter type clause. Alan, you want to mention the 754 election, so it's just on people's radar, because if they miss that, they're not going to
right.
get.
When somebody dies and they have an ownership interest in a entity taxed as a partnership, you don't get a step up on the inside basis of the assets of the partnership unless the partnership makes a Section 754 election. So that needs to really be, it's best to put that in the LLC agreement or the partnership agreement, that the partnership will be required to make a 754 election, because otherwise there may be a stinker that you have as a partner who holds you hostage to make that election.
Um, Also, if you're the accountant handling this client, if you're not familiar with some of the estate planning implications, and you may know 754 election, but if you really haven't been down this path, maybe you bring somebody in just to help you on this one matter. You don't want to not get this right, because then all the creative planning Alan just talked about could be lost. Alan, question on this convertible note: is it simply a clause that says automatically, on my death, the note that I am holding shall be converted into whatever fair value of partnership interests?
That's right. That's how I've
But
seen it.
it's not that complicated. It's like another paragraph in the note.
No, it's just one paragraph in the note. That's right.
Does that note have to have a lien on the asset to make that viable?
I don't think so. I mean, you may want to take a lien on the whole company or the whole interest that you're transferring so that it holds up better on the installment sale side. But I don't think there's any reason that it has to. And it might, from a 2036A standpoint, it might be better window dressing not to have it secured.
Well, that's an interesting thought. Yeah, there's always nuances to all of this. So let me change gears completely and talk about something that, again, unfortunately, we've been seeing come up more and more. And if you look at the statistics, it's shocking to me that all of us aren't seeing a lot more of this. And I think we're not seeing it because clients just aren't telling us. I had a situation where, and it was an astute financial advisor that picked up some subtleties in expenses on an account that really kind of broke this open. And we have a situation with a beneficiary with several different addiction issues, including drug abuse and gambling. And an astute financial advisor picked up some odd expenses and very delicately, politely, politically correct, raised the issue. And we started to explore it. Turns out there's been a history of drug addiction in the family for generations. We never knew. It's absolutely, and maybe if I were a mental health professional, I would have picked up on clues better than I did. But I've been doing this for a while. We've all been doing this for a while. They really, everyone that I dealt with in the family that now I know has issues, they really hit it incredibly well. I think it's important to keep in mind that we need to try to get clients to engage and tell us what's going on. We can't plan for things that could be very problematic if the clients don't open up and tell us about what's going on. And apropos to the observation by the financial advisor, this is why collaboration is so critical, because some of these little personal nuances that may be very intentionally well covered up and hidden. One advisor may get a clue, another advisor may get a clue, and together we can all kind of figure it out. Just one of the simple things that we changed almost immediately, as soon as we could, the senior generation wanted to give a whole bunch of the children and grandchildren a certain amount of money outright, a large estate, and you want to give 100 grand, 500 grand of, so they can just have some funds to do as they wish without the formalities of a trust. I don't love that in any circumstance, but okay, and we do it, and clients ask for it. But my gosh, when you have beneficiaries that have dangerous addiction issues, $500,000 could end up killing the beneficiary, literally. So this is a much longer discussion, and I have some other webinars in the hopper with a mental health professional on these that we'll tackle. But I think we need more discussion about all of this in the profession, and we need more programs and articles and webinars discussing this, because it is so much more common than we realize. And again, I don't think it's an overstatement to suggest that it was really very difficult, if not impossible, to discern. And these large cash bequests that, relative to the size of the estate, really didn't seem awful. Yeah, I did the general, put everything in trust. You should have everything in trust. But I didn't argue with them because I had no idea. We all need to talk about this more, and maybe even try to get better at identifying these situations. Alan, any thoughts or comments on that?
Yeah, we have very strong addicted beneficiary language in our trusts. They go for pages. I'm glad to share them with anyone. They were written with the assistance of a couple of psychologists. And what it basically says is, if you're not dry and you blew it, then you got to wait 60 months. You got to be dry for 60 months before you can go back to the standard of living that we've intended for you. And it's a monetary punishment and reward for dealing with the addiction. And a lot of people think that addicts are bad people or dishonest people, or they have weak personalities. Really, you're born with that addiction, and it screams and yells at you. Or you have tremendous anxiety, it screams and yells at you. So then you start taking some medication or alcohol to deal with that anxiety. And we can just all thank heaven that we weren't born with this predilection. It's a very, very difficult, serious situation. Some clients appreciate it and some clients don't. And some clients really don't want to tell you that their son is a drug addict and that they have to give him cash so that he'll stay quiet. And sometimes you can't deal with that until the client died, and a competent trustee can force the beneficiary to say, hey, go to rehab or live on the street. Those are your two choices. So it is something that every planner should have some familiarity with, the ability to call in someone to help you decide what's best for somebody, and recognizing that this happens in almost every large family, but more and more genetically, with genetic tendencies. So talking to clients about that is a pretty good idea.
Let me just bring in one last point of something that we had to deal with for this client. And I was a little surprised by it, but I appreciated the integrity of the trustee. The trustee that has been the institutional trustee for the family for a very long time said, listen, we're not the right trustee for this. This is not what we can do. And one of the things that also triggered a problem, whatever the level of wealth is at the parent level, when it gets divided by, in this case, 6 different pots, you now have trusts that each of which is well below the threshold level that the institution's minimum is. And when you have 3 or 4 of those 6 trusts with beneficiaries that require the kind of tough decisions and ongoing involvement that a trustee requires, the trustee said, listen, we're not the right people. We're not going to do the right job. So we went out and found a trust company that says, yeah, we do this all the time. Here's how we bill. Here's how we work. We're happy to help. So the decision about who the trustee should be is very important. And in a lot of the families that we've dealt with these issues, and like Alan said, a lot of people won't tell you, which worries me about how many have not dealt with them. One of the things that was done is they wanted to name one of the family members as a trustee. And the client, which was wonderful and doesn't always happen, was willing to bring in a mental health consultant that we had recommended. And we've been authorized to interact and discuss all of this with the mental health consultant, who's been instrumental in all the planning. And when I mentioned to this mental health expert that, you know, they wanted to name a certain family member as a trustee, she's absolutely bad. No, that will not work. So you know, if the clients can only be made comfortable, I think part of the problem for some clients is embarrassment, which it shouldn't be. Part of the problem is they don't understand, the clients don't understand how much we can do to proactively help them if we only know what's going on. I would never have brought in the particular institution that is now involved. I would have never given them such kickback on naming a family member as a trustee and so on. So it's very common and something that really needs to be looked at. Alan, I think we're starting to get to the end of time, but we should talk a little bit about AI, because we always talk about AI, and it seems at the pace this is changing, there's always something new. Do you have any AI thoughts? I have a few after you.
Well, I just have to, I've been to some social events recently, and there's just a lot of lawyers and other professionals not using it yet at all, and they really don't know what they're missing. They really don't know what they can do better, faster, and more thoroughly with the AI. So all the caution that's been thrown out there, which is merited, has caused tremendous underuse, and a lot of law firms, quite frankly, have a lot of potential they're just not tapping into right now.
I agree with that, because most of the discussion that I see, and I don't know how to estimate it, but 80% of the conversations have been about the ABA ethics opinions. Very important to know. They've been about the Hefner case, which voided privilege for certain AI research, and the Mata and other cases where people had hallucinations. Those, yes, we have to be mindful of all that, but that's, you know, those are the issues. But what about all the things you can do? Too much of our attention has been focused, and I'm not criticizing it because it's important and it's new and you don't want to get your backside in a ringer, but we need to talk more about all the positive things that it can do. We've talked about conflict checks. It revolutionizes what you can do on a conflict check. We've talked about background checks even earlier in this program. Let me just mention a couple of things that I've done. I had a client that I had a consultation with, and there was a particular issue that addressed a real property holding and certain real estate title and tax issues in a jurisdiction I don't practice in. And I really didn't know what the law was. But what I did is I asked AI to get me some, my phone is talking to me and I don't know why I didn't even touch it.
It's that AI.
To get some information on the question. And I did that because it was important to the planning. I can talk to him about what happens with that. And I made it very clear that he has to hire counsel in that jurisdiction and that I have to be authorized to talk to that counsel to complete the plan. I didn't want to run up a big bill on researching that state's law, but I needed to have some idea what was there, because I'm concerned that if he hires just a person who just does house closings in that jurisdiction, they're not going to have the sophistication to understand it. I just wanted to raise issues and said, you know, you got to talk to the attorney in that state about this, about that, and raised all kinds of issues. what I did, because I didn't feel it fair to charge the client, and it's not my specialty to research that other state's law, I didn't want to run up a big bill on that state's law. So I put a disclaimer and I made it bold and yellow highlighted that this is preliminary AI research that I have not corroborated and only am listing here so that I can raise questions for him to speak with counsel in that jurisdiction. So I felt that I've given him now a bit of a roadmap, so he'll have a lot of specific things to ask that counsel, and he'll make sure the counsel can answer the questions. But I didn't want the liability, like, what if AI didn't give me the right rules? But I also didn't think it fair to spend the hours researching all this. Alan, any thoughts on that? It's a different way to do something that in the past I probably wouldn't have done, because if I just Googled it, I wouldn't have gotten much out of it.
Yeah, I mean, when I write the letter to the client, I say in my letter, hey, AI, tell me whether Montana recognizes tenancy by the entireties, and if so, is it the same as Florida, and how does Montana do on charging order protection? And what do I need to know to put a shopping center in Montana in an LLC? And then I choose Gemini, ChatGPT, or Claude. It gives me the answer. Then immediately one of the other ones checks it. It's almost always right. It's almost always right. So then I'm double checking if I'm using a lawyer in Montana to help me. And it just makes it so much faster and so much easier. And it doesn't take long for a law student or a young lawyer to review the results of that research and to say, yeah, he got it right. And he got it right in 15 minutes instead of 15 days.
But I think we need to think about, if we're not going to spend the time to check, all right, here's a statutory reference. Did I separately look up the statute? Yeah, you may have checked it, but I think that's kind of the lesson from the Mata case, if I'm pronouncing it right, MATA. But I didn't want to spend the time doing that. I don't think I needed to do it because he's going to go to local counsel. But I wanted, just like you said, I wanted to have some idea where this is all going, because it's so critical and intertwined with what I'm doing. But I think there's nothing, I think, and I this is the first time I've told anybody, I think it's protective of me and honest with the client to say, this is what I did. I have not, but that's important to do. In that case, this wasn't like me going to court with a brief. You better have that right. But giving preliminary comments for somebody to review with local counsel, I think is more efficient even for local counsel, because when the client calls local counsel, they're not going to really know what to ask. Now they have a list of questions. But
quite frankly, local counsel may get it wrong. So if local counsel tells me something and Claude and Gemini together are telling me something else, I'm going to read that law myself. I'm going to read that statute. I'm going to read that case, and I'm going to figure it out.
But at this juncture, I didn't want to spend the time reading it.
Right.
I just wanted to raise the issues. But I think this is an example of how nimble AI can be to help us get a grasp on how components of the plan that we couldn't have figured out before. And if local counsel comes back and tells me something that doesn't make sense, I'll go and follow up more. But I think it's a great service for the client. It really didn't take a lot of time, and it had some fascinating implications to New York law that I hadn't even thought about until I saw what some of the locals, that other state's law was.
Yeah.
Have you used AI to do timelines for plans or litigation support or anything like that?
I personally have not, but I'm sure it will very well.
So I have several expert witness matters that I'm working on where I'm having to evaluate trust plans and the implications to matrimonial matters. And the data is voluminous, as it always is in those cases. And understanding the sequence is really important. How close before the wife filed for divorce did she transfer assets to that self-settled trust, or things like that? It's not always accurate, so you have to double check it. But it's amazing where you can say, look for the Smith versus Jones file in our system and identify every date that's listed anywhere and give me a timeline. I mean, a lot of the stuff it comes back with is not really relevant to what I'm trying to analyze, But it could take an associate or a paraprofessional days and days of time to do this, and it comes back with everything. Not only can it come back with everything, it gives you a link to the document. So think about how easy it is to check it. And it was fascinating because there was like rounding errors in some of the LLC membership interests. That helps my client's case because it's not adhering to formality. There were some dating differences. Some of the things it came back and said there is no date the document was signed, but it had an effective date. Well, based on the Smaldino case, that's a little suspect. In a matrimonial case, it's really worrisome. And by the way, they were all dated January 1 or December 31. You don't go vacation. Who's in the office on January 1? But using AI to cull through, if you give it parameters like that, I think is an incredibly powerful tool. You have to check it. But when you have links directly to the document, it's what a time saver. In less time than I would have explained the assignment to an associate, I had a preliminary timeline. It didn't get everything because I'd been studying the file, so I went back and added to it. But what an incredible time saver.
No doubt.
One last one and then we'll end.
Sure.
So I don't want to say too many details, and it's almost an embarrassing situation. But I know that you, Alan, for sure have the same challenge that I do. And many, but certainly not all of our colleagues have the same challenge. The matrimonial attorney evaluated this, I don't know, 30, 40 page report that I issued, said, this is really good, this is really strong. Then she said, no judge is going to understand it or read it. It's too long and it's too complicated. How about you write a 2 or 3 page summary, high level summary, and attach this detailed report as the exhibit? So I said, AI, please write at a 10th grade level a summary of the following 40-page report. It gave me an output. I had, I think, 7 or 8 distinct theories for unwinding this trust transaction. And when AI gave it to me, it had them in with different names and order. I said, please redo the summary that you gave me and track the numbers and titles of each of the actions or arguments that I made. Bam. It was a simpler, more readily understandable summary. And I read it because I made some corrections, but it was written much more simply than I'm accustomed to ever writing. And it did the trick. So when you need to do a certain tone or level, you can do it. And I thought of something else that I was tinkering with, and I haven't gotten anywhere, but Alan, I'm going to bounce this off you and then we can wrap it up. Where you have a client that is competent, and that's obviously a legal determination. We're not relegating to AI, but you need to communicate to a client that is struggling with health issues, cognitive issues, aging issues. You could take a memo that you've written and say to AI, please rewrite this at a 12th grade level. Please rewrite this. Don't change anything. Don't delete anything. But reformat this so that you have short sentences and lots of bullet points. You can even say to AI, if there's mention of different entities or trust, draft a schematic. And it does it all. What an incredible tool to take something more sophisticated that we're used to writing and making it digestible by any client. I never learned to write short and simple, did you?
No.
But AI can do that.
A lot. AI takes my dictation, listens to it, and then types something up better than I would have. But then I always put it on screen and check every single word.
Oh, absolutely.
Have to do that, but it's still
absolutely
dramatically better and faster than what we were doing 6 months ago.
But it also has that knack to make things simpler, because for all of our careers, we're always looking at these nuances like we talked about with Netter, and I need to hear your comments on it, but we're looking at these fine nuances of language and statutory interpretation, and a lot of clients it's just too deep for.
Yeah.
And if you can start with the high level explanation, then they'll understand it if they have to go through the more detailed. And
Absolutely.
yes, we obviously have to read it. We still have work to do. We're not obsolete yet.
Not yet.
Alan, I give you the last word. Words.
Well, I will mention something about estate view. We have the AI now working in the calculators and in our married client comprehensive calculator, where it reads the inputs, it reads the outputs, and then it discusses it, tells us what to change, and then can even change the inputs and recalibrate and rediscuss the outputs. So we don't have to trust it with the accuracy as to the numbers, but it's helping us better understand the numbers, and it's very, very darn smart. It's really interesting.
And think about what it's going to do in 5 years from now.
Yeah, yeah.
See, that's why when you tell me, and I've had the same experience, it seems to me that the significant majority of practitioners are barely poking their toe in. You know, maybe they'll use AI to help with research, or they'll do it inside of a program they have, but they're not thinking proactively about all the little nuances and tasks that you can have AI help with. And it's moving so fast that I'm afraid to get off this train, because how am I ever gonna get back on?
Yeah, yeah. Well, for now, it's enjoyable and it's saving a lot of time and helping us be more efficient and helping us be better lawyers and professionals. So I'm good with all that.
Thank you, Alan. Thank you, everyone, for joining us. Please email us comments, thoughts, suggestions. We hope that this sort of different approach than a formal webinar on a specific topic, where we just talk about things we see going on, whether it's a new case, a planning idea we may have just used, or, you know, Alan brought up preferred partnership freezes, and 6 months ago I was looking at an issue that I thought might be of note on using some type of adjustment mechanism. Hopefully this is relevant and helpful to you. Different, I understand. We welcome any comments, suggestions, even criticisms, although be gentle. Thank you for joining us, and wish you all the best.